Thank you for being here again for the next update and episode of our Friday weekly podcast, the Class Action Weekly Wire. I'm Jerry Maatman, a partner at Duane Morris, and joining me today are my colleagues and fellow partner Mike DeMarino and associate Randy Kim. Thanks so much for both of you being here on the podcast.
Oh, it's great to be here. Thank you, Jerry.
Thanks for having me, Jerry.
Absolutely. Today we wanted to discuss trends and important rulings in the area of antitrust class action litigation. To your way of thinking, what were some of the most significant developments in the class action world in 2022 in the antitrust space?
I think what the most important development that we saw was really an expansion into the labor market from traditional areas of antitrust focus. So historically, antitrust enforcement has focused on areas in price fixing and other anti-competitive conduct in sales and product markets. And more recently now, there's been a growing recognition in the intersection between antitrust violations and the labor markets. And this in turn has led antitrust authorities to increase scrutiny over labor markets, and for the plaintiffs' bar to really piggyback on that momentum and push the limits of class actions to recover employment-related antitrust violations.
Mike, what do you think that the plaintiffs' bar has targeted this particular area? What do you attribute this growth to?
I think it's really attributed to them pushing the envelope in terms of trying to be creative and find new gold in the mines, price fixing and other anti-competitive areas in traditional markets, sales markets and products markets is tried and true. But here what we have is there are a number of companies that for years have no poach agreements in their employment contracts or solicitation provisions in their contracts. And so really the plaintiffs' bar is tapping into this area to essentially get gold out of the mine and find new ways to expand potential litigation.
Randy, I know you're a thought leader in this space. Do you think that the Biden administration's position on antitrust issues is also driving this private plaintiff class action litigation in the antitrust space?
Oh, absolutely. I agree with everything Michael said, that the expansion has really been a consequence of what we saw with President Biden's executive order in 2022. I think that was July. It was an expansive statement of their goals for competition policy for the administration. But within it was a clear declaration that the Biden administration would pursue actions in labor markets. And consequently, the Department of Justice and the Federal Trade Commission have been diligent in bringing these prosecutions, although it took a little while to get going. And then as we see in other areas of antitrust litigation, the plaintiffs' bar follows up on those actions as they do on other antitrust actions, especially with these lawsuits where the plaintiffs' bar is able to identify no poach agreements that might be conducive to this kind of argument.
Mike, were there any rulings in 2022 that would nicely dovetail with this interest between the Biden administration and the private plaintiffs' class action bar?
Oh, absolutely. What we saw in 2022, really a target, the plaintiffs' bar targeting franchisors. And so there's a case in the Northern District of Illinois, Landis versus McDonald's, where the district court denied class certification of a nationwide class of McDonald's workers, primarily on the basis that plaintiffs failed to satisfy Rule 23b3's predominance requirement. And so the court denied class certification on that basis. And really what led to that conclusion was the court's determination that it was going to apply what we call the rule of reason analysis, which is in essence an evidentiary burden for plaintiffs. that requires them to establish an anti-competitive effect or impact in a relevant market. In this case, the relevant market is the labor market. And so the court concluded that because this was a nationwide class action spanning coast to coast, and there were hundreds, if not thousands, of local labor markets, plaintiffs wouldn't be able to satisfy, at least not with class-wide evidence, that there was an anti-competitive impact on the labor force. And so because of that, individualized issues overwhelmed common issues, and it led the court to deny class certification. And really what we've seen is that become a battleground in 2022, that question of whether per se treatment or rule of reason treatment is going to apply to a claim, because it has drastically important consequences for the evidentiary burden, even at the pleading stage for plaintiffs.
Now, Randy, I know the Department of Justice sought to intervene in the McDonald's case, both at the district court level and on appeal at the Seventh Circuit. What should our readers take away from the activities of the Department of Justice in terms of its interest and litigation of these issues in the McDonald's case?
Yeah, so that's an excellent question, because as you allude to, prior to Deslandis, the DOJ had put out a policy position, forgive me, I forget the format in which they used, where they essentially said a sort of hands-off approach to a lot of these covenants and employment agreements, and saying that in most situations that these should be analyzed under a rule of reason, which is a more understanding standard for when you can do something that might have competitive consequences. With the Deslandis case, the Department of Justice's position switched, and this is in line with the Biden administration's renewed focus on a more vigorous enforcement approach. And so what happened is, even though the DOJ weighed in on the Deslandis case, saying, these should really be analyzed under a per se approach, the markets are the same, the analysis is the same, we have all of these antitrust tools that should apply just as easily to labor markets, courts were not fully convinced. And I think the Deslandis opinion shows that despite the DOJ's new position that this is same old antitrust analysis, courts are not incredibly comfortable with the notion that all of these agreements should be analyzed under a per se standard. And as Michael said, it's really becoming the battleground or the determinative factor in whether a no-poach class action can get certified at all.
I'd be interested in both of your takeaways, the notion that class certification is the holy grail, and that in class actions, they're so big, they're so weighty, they're worth so much money, and in the antitrust context, you have trouble damages. Is the whole game or the battleground at class certification, or are there other aspects of antitrust class actions that you think are important, and what might those be?
That's a good question. Absolutely. The order granting or denying a motion to certify a class is going to be the most critical point in the lifespan of a class action. A decision granting class action has the potential to blow up the case, and a decision denying class action has the potential to devalue the case all the way almost to zero, rendering it just a nuisance value case. Plaintiffs often in antitrust class action seek class certification under Rule 23b3, which requires that they satisfy the predominance test, demonstrating that common questions of law and fact predominate over individual questions, and that in turn is an extremely fact-intensive inquiry into both the availability and adequacy of common evidence. And so on the one hand, you have the class certification decision itself being, a critical juncture in the case. And I would just add the other important areas are the discovery that goes into that determination, just because it is so fact intensive.
Yeah, and I'll echo what Michael said about how significant the class-wide certification is, and potentially turning a cause of action into almost a nuisance suit. We might talk about later if your class is if the cause of action is alleging some wrongful anti-competitive conduct based on an app that you bought on your cell phone for $1.50, then the litigation over that kind of amount isn't as productive as a giant class that might get certified. I think a good example of a ruling that's hinging on this predominance inquiry was from the Ninth Circuit. And that case was Olean Wholesale Grocery Co-op Incorporated v. Bumblebee Foods LLC. So Olean involved direct and indirect purchasers of packaged tuna seeking recovery for an illegal price fixing conspiracy against 3 large tuna suppliers. And after the suppliers pleaded guilty or admitted to charges in exchange for leniency from the DOJ in 2015. The district court held an evidentiary hearing to hear the battle of the experts between the two parties, and it held that the plaintiff's statistical analysis was sufficient under the 23b3 predominance requirement to show common questions, and it certified 3 classes of plaintiffs. As a little side note, the en banc Ninth Circuit affirmed the district court's class certification after an initial challenge had produced this argument from a number of judges on the Ninth Circuit that there were too many uninjured class members, or there were questions about the uninjured class members. And the en banc Ninth Circuit affirmed, they rejected any de minimis rule about the number of potentially uninjured members. And they held that such a rule would be consistent with the text Rule 23.
Now, one of the benefits that our clients talk about in utilizing the Duane Morris Class Action Review as a research tool is the data within it regarding class certification conversion rates. How did defendants and how did plaintiffs do in 2022 when it came to winning and losing class certification motions in the antitrust space?
Defendants edged out plaintiffs in terms of winning class certification. So in 2022, we saw plaintiffs win 37% of their class action motions. And by contrast, defendants were able to secure a denial of class certification 63% of the time. And the common denominator among these decisions really is how the fight centers around, again, and how there's complex inquiries centering around whether common issues and common questions or individualized issues predominate in a particular case. And so 2 cases kind of come to mind that drive home that point, where classes were denied, class certification were denied because of the lack of predominance. And one is a case called Neipel et al. Versus J.P. Morgan, where the court credited the lack of a reliable methodology for calculating damages through common proof as one of the additional factors in denying class certification. And then the other case is a case called Value Drug Co. et al. Versus Takeda Pharmaceutical, where the court determined that plaintiffs failed to produce sufficient evidence to show that common issues predominated. So again, that predominance inquiry rearing its head up again in pretty much all of the class certification motion decisions.
Randy, where plaintiffs were successful in certifying their antitrust class actions, what were the sorts of theories or what was the glue that held their cases together that led courts to certify the plaintiffs' claims?
As we mentioned before, the stakes are enormous. In 2022, the District Court for the Northern District of California granted certification to a class of over 21 million consumers in re Google Play Store antitrust litigation. I believe that's one of the largest classes that has ever been certified in an antitrust class action. Ultimately, the court found that the plaintiff's expert witness testimony and models, while not dispositive, were sufficient at the class certification stage to have its probative value determined later by the fact finder.
There have also been a lot of settlement activity, and there have been attorney's fees awarded just this last week. The 10th Circuit in an antitrust class action awarded $503 million to class counsel for successfully prosecuting and then settling an antitrust case. In both of your minds, what were the key settlements in 2022, and what do you foresee happening on the settlement front in 2023?
The settlements are huge. The numbers are just astronomical, and that is really what drives the plaintiffs' bar to push theories to recover in these cases. In 2022, the top 10 antitrust class action settlements totaled over $3.7 billion, and the largest settlement was $2.67 billion in a case called In Re Blue Cross Blue Shield Antitrust Litigation. And that settlement resolved claims that health insurance companies violated the Sherman Antitrust Act by entering into an unlawful agreement to restrain competition between markets selling health insurance. And so really these astronomical settlements is what drives the cases. And so in 2023, there will definitely be more suits to come. Plaintiffs will continue to push the theories in order to obtain these type of settlements. And your question specifically, Jerry, about the recent 10th Circuit affirming $503 million attorney's fees award. That was almost a case unto its own, because that devolved into litigation over the attorney fees petition, and that was a case out of the 10th Circuit called In Re Syngenta Antitrust. And Syngenta is a manufacturer of corn seeds. And what happened in that case is that there were several groups of farmers that sued Syngenta because it had released GMO corn seeds into the Chinese markets without obtaining the necessary Chinese regulatory approval. And when China discovered this, it essentially closed all of its doors to U.S. corn suppliers, resulting in alleged domestic damages in excess of $1 billion. And so this case settled after hundreds of lawsuits were filed and were combined in multi-district litigation. It settled in 2018 for $1.5 billion, with $503 million allocated for attorney fees. And as you can imagine, when you have that much money at stake and that many plaintiffs' firms jockeying for a seat at the table, the fee award was challenged. And on appeal, after a 179-page opinion that said this, the 10th Circuit affirmed the district court's fee award. But that just demonstrates, the damages, the exposure, the fee awards that are at stake in these type of cases, and why there's no stopping these cases in 2023.
That's an incredible start to 2023. Randy, how about on the government front with the DOJ and the Federal Trade Commission? What are the takeaways that corporate counsel should be looking for in 2023 on that front?
Yeah, well, the plaintiffs' bar will continue to try to win class certification to push settlement numbers by using advanced methodologies. The DOJ and the FTC are going to publish new merger guidelines. And although that won't change laws, plaintiffs' counsel could use them as authority in the courts. The FTC also in January proposed a rule to ban employer-worker non-compete clauses and rescind any clauses in place. So we see this kind of approach to labor markets expanding as the DOJ and FTC really gather steam. If finalized, this rule would lead to a major change for many employers, and we're sure to see a lot of debate and argument concerning those arrangements.
Well, Michael and Randy, thank you so much for your analysis and your contributions. Loyal blog readers, we hope you enjoyed our second podcast today, and please tune in next week for our third. Have a great day.
Thank you so much.
Thank you.